Welcome to the deep dive. We are diving into some sources you've shared with us today, taking on the really intricate world of Florida medical malpractice law. Specifically, we're looking at something that sounds simple, damage caps, but, well, it quickly gets complex when you start asking, who can recover and how much?
It really is a maze, full of specific legal distinctions. And your sources, especially that analysis called McCall analysis, are caps constitutional, another point of view, plus the clarifications. They really force us to unpack those nuances carefully.
That's exactly our mission today. We want to cut through some of the noise, understand the specific legal concepts these sources are highlighting, and really get to the heart of a crucial Florida Supreme Court decision. And also see why getting these distinctions right is absolutely critical for, well, for anyone thinking about potential changes to the law down the line.
Okay, sounds good. Let's grab our metaphorical shovels and start digging for those important nuggets of insight.
Great. Let's start right where your source begins, by clearing up some potential confusion around a specific law, Florida Statute Section 768.21 and 8. My understanding is the source says this one is often mislabeled.
Precisely, yeah. The source makes a very strong point that calling Section 768.218 a damage cap, even if you say it rhetorically, like a 100% cap, is fundamentally incorrect and legally misleading, actually.
Okay, so if it's not a cap on the amount you can recover, what is it doing then? Because that sounds pretty significant.
It is significant. It's what's called an exclusion statute. So according to the source, it works by completely prohibiting certain individuals from recovering any non-economic damages at all, specifically in wrongful death medical malpractice cases.
Prohibiting entirely. You mean like they have literally zero right to even seek those damages?
Exactly. Think about specific family members. The source mentions parents whose adult child died or adult children whose parent died but wasn't married. Because of this statute, these specific people are legally barred. They can't recover for things like their profound grief, their loss of companionship, or, the mental pain and suffering from losing their loved one due to medical negligence.
Wow. Okay, so it's not about putting a limit on how much a jury might decide to award them later. It's saying you, because of who you are in relation to the person who died, have no legal standing to even ask for this type of compensation in the first place.
That's the absolutely crucial difference the source hammers home. It denies standing for that specific type of damage. A jury never even gets to hear about their loss in that respect because the law prevents them from bringing that part of the claim.
Okay, let's really make sure we understand this. Why does the source say this distinction, statutory cap versus statutory exclusion? Why does it matter so profoundly? How does mislabeling actually weaken legal arguments?
Well, because they represent fundamentally different legal concepts and, frankly, different types of injustices. A statutory cap puts a ceiling on the amount of damages a jury can award for certain things, usually non-economic damages like pain and suffering. The claim itself still goes forward, a jury evaluates the loss, listens to the evidence, but the final payout might get reduced by that cap figure.
So the claim exists, the jury is involved, the loss is acknowledged, but the final number might be cut back by the law.
Right. But a statutory exclusion, like Section 68.21, according to the source, is a completely different beast. It's a rule that prevents certain people from ever getting to that point for those damages. It says you specifically cannot recover these damages at all, period. No recovery is permitted for you, and the jury never considers your specific loss in that category because your legal right to seek compensation for it has been removed by the statute.
That is a huge difference. One is about limiting the value assigned to a proven loss. The other is about denying the right to even claim that the loss is legally compensable for you as an individual.
Precisely. And the source argues that confusing the two really obscures the core issue with Section 768.218. The problem isn't just about limiting money, it's about denying access to justice, denying the right to seek compensation for a very real injury felt by specific people.
Got it. Okay, with that critical distinction now clear, cap versus exclusion, let's turn to a pivotal moment in Florida law on this whole topic. The Florida Supreme Court case, the state of McCall v. United States, that was back in 2014. What was the core issue in the ruling there, based on what your source tells us?
Yeah, the McCall case is absolutely central to these debates. The source explains that the court looked at a different statute, Section 766.118. This one imposed a cap on non-economic damages, specifically in wrongful death medical malpractice cases. It capped those damages at $1 million per incident. And the court found that this cap violated the equal protection protection clause of the Florida Constitution.
Okay, and the reason for that violation?
Right.
What made it unequal? Why did it violate equal protection?
So the source clarifies it was all about how the cap was applied in cases where there were multiple surviving family members, multiple claimants. The court found that this per-incident cap arbitrarily and unfairly reduced the total amount recoverable for families that had several survivors, especially when compared to families that only had a single claimant.
Right. So let me see if I get this. Imagine a terrible medical error causes a death, and a jury determines the family's total emotional loss. The non-economic damage is worth, say, $1.5 million. If there's only one surviving spouse or child, they might potentially recover close to that full amount, subject to the cap maybe, but at least the potential is there. But if there are, say, 3 surviving children who all suffered that loss, that same $1 million per incident cap forces their total collective recovery down to just $1 million.
That's exactly.
Effectively treating their combined suffering as less valuable than the single claimants.
That's precisely the scenario the court found created an arbitrary and unconstitutional inequality among people in the same category, the category being wrongful death claimants. It essentially penalized families just for having more loved ones who survived and suffered the loss.
Okay, that makes the equal protection issue very clear within that specific group of wrongful death claimants. But the source is also very careful, it seems, to point out what McCall did not decide. What are the key limitations of that ruling?
Yes, and this is absolutely vital for the source's larger argument. McCall did not declare all non-economic damage caps in all medical malpractice cases unconstitutional across the board. It wasn't some kind of blanket ruling against all caps.
He's really specific to that particular cap, in that specific type of case, wrongful death, with multiple claimants.
Exactly right. And crucially, the source highlights that McCall did not address personal injury claims or survival actions. These are the claims brought by or on behalf of a victim who actually survives the medical negligence. McCall was focused solely on the unique context of wrongful death claims, particularly where multiple survivors were involved.
And it didn't sort of mandate that the law has to treat every single type of claimant exactly the same way when it comes to damages.
Correct. That's a key takeaway from the source. It argues McCall addressed an internal inconsistency, meaning unequal treatment within the defined group of wrongful death claimants. It did not require that totally different categories of claimants, like, say, someone who survives a catastrophic injury versus a family member grieving a death, must be treated identically under the law regarding damage caps or frameworks.
This distinction seems to bring us right to the core constitutional argument presented in your source, doesn't it? This idea that surviving victims of medical negligence and the surviving family members of wrongful death victims are not, in legal terms, similarly situated under the Equal Protection Clause. And therefore, the legislature can actually treat them differently regarding damage frameworks without automatically violating the principles laid out in McCall.
That is absolutely the central constitutional and, frankly, strategic argument the source is making. It contends there are fundamental reasons, legal, doctrinal, even moral reasons why these groups are different in the eyes of the law. And because they're different, treating them differently when it comes to damages is legally justifiable.
Okay, so what are the main reasons the source gives for saying these two groups are legally distinct entities?
Well, firstly, there's a fundamental difference in legal standing and the actual nature of the claim itself. A survivor of medical negligence, someone who lived through it, is suing for their own physical injuries, their own pain, their own disability, their loss of function or quality of life. They are the direct victim.
Yeah, the primary injured party.
Exactly. Now, surviving family members in a wrongful death case, they are suing as third parties. This is key. They aren't suing for the physical harm that was done to the person who died. They're suing for their own distinct injuries that resulted from the death. Things like the loss of the relationship, the emotional anguish, the lost guidance, companionship, that sort of thing.
Okay, that makes a lot of sense. The injury itself is different. One is personal physical harm and its consequences. The other is more relational and emotional harm caused by the loss of a loved one.
Precisely. And secondly, the source points directly to the type of harm involved. They argue these harms are qualitatively different, and they unfold differently over time as well. Survivors of severe medical negligence often face, years, maybe even a lifetime, of chronic physical pain, permanent disability, the need for ongoing medical care, and a profound, very tangible loss of their ability to live life as they did before the negligence.
That's a direct, ongoing impact on their own daily existence.
It really is. Now, surviving family members, while their suffering is immense and absolutely real, experience a different kind of harm. intense emotional loss, deep grief, the permanent void left by the relationship. The source basically contends that trying to just equate these two very different kinds of suffering under a single uniform damage framework isn't really accurate or even just.
So the argument is that allowing the law to acknowledge these different realities actually respects the fact that these are distinct human experiences and distinct types of injuries.
That's the core of the argument, yes. It allows the legal system, and potentially a jury, to respond proportionately to these very distinct categories of injury and societal concern. The source also notes that this is already reflected, to some extent, in the distinct legal frameworks that exist. The rules for personal injury or survival actions when someone lives are already different from the rules for wrongful death actions when a family sues after a death. Things like who can be a beneficiary, what types of damages are available. They're not identical.
Okay, so pulling all of this analysis together then,
Yeah.
what are the big strategic and constitutional implications the source highlights? Especially thinking about any current or future legislative attempts to reform Florida's medical malpractice laws.
Right. Well, one key strategic point the source makes is basically avoid expanding the battlefield unnecessarily. It warns against the idea of lumping together survivors of medical negligence with wrongful death claimants under some kind of single unified cap. Survivors' claims are already legally distinct, and they weren't even part of the legal challenge related to the wrongful death exclusion in Section 768.218. So the source argues, why drag one group into a policy debate or potentially a new legal challenge that was prompted by issues affecting a completely different group?
Yeah, that makes sense. Don't try to fix a problem for one group, but potentially creating new problems or limiting rights for another unrelated group.
Exactly. Another major implication the source draws from its analysis is that there is no constitutional mandate for uniformity across these different claimant types. Since McCall, according to the source, only required equal treatment within the category of wrongful death claimants, the legislature is constitutionally free, so to speak, to treat survivors and wrongful death families differently when they're crafting damage rules. This means, for example, they could potentially restore the right to seek non-economic damages for those people currently excluded by Section 768.21 AT without feeling constitutionally obligated to also impose new uniform caps on surviving victims just to satisfy the McCall ruling.
That's actually a really powerful insight. Restoring a right for one specific group doesn't legally require limiting a right for another legally distinct group under this interpretation.
It's certainly central to the source's perspective, and tied to that is the final strategic point. Different harms justify different remedies. Because the injuries are fundamentally different, direct physical harm versus relational emotional loss, the legislature is justified, the source argues, in accounting for those differences in any damage framework they create. It suggests a one-size-fits-all cap isn't constitutionally required and might actually be poor policy because it fails to acknowledge the distinct nature of the suffering experienced by survivors versus that of grieving families.
And the source concludes, then, that this entire line of analysis provides a pretty solid foundation, legally, doctrinally, maybe even morally, for arguing against bundling survivors and wrongful death claimants under a single, uniform cap system.
Yes, that's the takeaway. Arguing that forcing entirely different kinds of victims into the same legal mold, treating their losses as interchangeable, could be legally unsound. It might even invite new constitutional challenges down the road precisely because it ignores these fundamental differences in their injuries and their legal standing.
So, after all that, what does this really mean? Looking at your sources, we've certainly taken a deep dive into the sometimes hidden specifics of Florida law and the real nuances of that McCall decision.
We definitely have, and I think we've uncovered that crucial difference between a statute that completely bars recovery for certain people and exclusion, and one that merely limits the amount they can receive a cap, and why getting that terminology right actually matters in legal and policy debates.
Yeah, and we've seen that the powerful McCall ruling, while significant, was really focused specifically on unequal treatment among wrongful death claimants. It didn't issue some broad mandate for uniform caps across all types of medical negligence claims or for all victims.
Right, and perhaps most importantly, we've explored the source's compelling argument that the law can and arguably should recognize the fundamental differences. The differences in suffering and legal standing between someone who survives a medical injury and a family member who loses someone to medical negligence, and that these differences can justify different legal treatment regarding their damages.
It really highlights the kind of complex balancing act lawmakers face, doesn't it? And it leaves us, and maybe you listening, with an important question to consider as you think about this topic further. How should legal systems effectively balance that need for Predictability and consistency in the law, with the absolute necessity of acknowledging and responding justly to the profound and often very distinct differences in human suffering.